Some NALSAR students had objected to the invitation extended to the Chief Justice of India to their convocation. The issue escalated, and the Bar Council of India then issued a communication directing state bar councils not to enroll the entire 2026 graduating batch of NALSAR as advocates. That obviously triggered a pretty serious backlash. The BCI subsequently withdrew the direction, and its chairman also issued an apology. The issuance of an apology and the withdrawal of the circular itself has gotten the immediate controversy to a close to a great extent, but it leaves behind a more fundamental question that needs some thinking. It brings the question naturally in the minds of people that who really decides who gets to become an advocate in India? That is, what is the legal framework governing the entry into the profession? And is becoming a lawyer in India a matter of a statutory entitlement or a discretionary privilege? And lastly, now that the circular has been withdrawn, what happens now? So once you graduate with your law degree from your law school, there are certain statutory requirements you must fulfill before you can be enrolled as an advocate with the bar. Here you undergo the system of your respective state bar council, which is the body that enrolls you as an advocate. The BCI, or the Bar Council of India, has certain statutory, regulatory and supervisory powers of its own. So there are a series of institutional actors and regulators that stand between your degree and your ultimate entry into the profession. The question is, what is the extent of this regulatory power and where does it come from? Section 24 of the Advocates Act deals with the person who may be admitted as advocates on a state roll. It lays down the statutory qualifications for enrollment, including the requirement of a law degree and other conditions specified in the provision. Then you have Section 25, which deals with the authority to whom an application for enrollment is made, and Section 26, which deals with the disposal of that application. So the Act itself creates a statutory framework for entering into the profession, and then separately, the BCI has regulatory and supervisory powers under the Act. Section 48B, for example, allows the BCI, in the exercise of its general supervision and control, to give directions to the State Bar Council for the proper and efficient discharge of its functions. Now, Section 49 is particularly relevant here and has also been cited by the BCI since it provides the BCI the power to make rules under the Act, including with regards to the class or category of persons entitled to be enrolled as advocates. So there are two things over here. One is the express statutory powers created by the Advocates Act itself that we just saw, and second is the rule-making powers that Section 49 provides to the BCI to make rules subject to the provisions of the Act. Now there's a fairly recent judgment of the Supreme Court in the case of Gaurav, Kumar versus Union of India over the general issue of enrollment fees. The court dealt with the question that can the State Bar Council impose an enrollment fees that went over and above what was prescribed by the Advocates Act itself. This is not a judgment cited in the NALSAR controversy or something that dealt with the issue of enrollment per se, but this is a judgment which highlights the ambit of the powers that can be exercised by the bar councils or bar authorities. The principle was that the bar council's regulatory powers have to derive from and remain consistent with the Advocates Act. The regulator cannot use delegated rule-making power to effectively add a substantive condition to enrollment that Parliament hasn't itself provided for. So you have the parent act and then you have the rules and regulations made under it. The second cannot simply rewrite the first. Now the relevant statutory scheme in this case is Section 24A, which deals with the disqualification for enrollment. Section 24A sets down 3 grounds for disqualification: conviction for an offence involving moral turpitude, conviction under the Untouchability Offences Act 1955, and dismissal or removal from state employment on a charge involving moral turpitude. Now, this constitutes of the exhaustive list of grounds for disqualification and does not include grounds such as participating in a student campaign or inquiry into the university students. And the question becomes, is this an act of regulating an existing statutory condition or creating an additional one outside the statutory framework? The BCI did cite Harish Uppal versus Union of India to establish the disciplinary and regulatory authority over advocates. However, it has been criticized for being fundamentally misplaced owing to the fact that it concerned advocates, and this amounted to lifting the court's observations from the context in which it was made to another scenario altogether. So this raises an interesting question about the ambit of delegated legislation and regulatory authorities' action. The state bar councils are the ones which decide upon the enrollment, and grounds for qualification and disqualification are laid down in the Act. The BCI's rule-making power functions within the framework of the Act, and if a rule is to be made beyond the statutory framework itself, it needs a legal source for doing so. So is becoming an advocate a matter of a right or a privilege? It does not fall neatly within either of those categories. It is not an unconditional right, since it depends upon satisfaction of the various requirements of the Advocates Act. But it is not a matter of administrative discretion. There is a statutory framework. Once that framework is satisfied and the legitimately made law is satisfied, the regulator's discretion functions within that statutory framework. Now the circular has been withdrawn and an apology has been issued. Can anybody still challenge the circular, and is the challenge to the circular still living? The short answer is that the withdrawal does not automatically make a challenge non-maintainable. It can make a particular prayer, like a prayer to quash an operative circular, infructuous, but that is not the same thing as saying that every legal issue arising from that circular disappears. If there are continuing consequences, threatened action, or some other effective relief that the court can still grant, the dispute may continue. And that's particularly relevant here because NALSAR matter has reached the Supreme Court, and despite the withdrawal, the court has continued to consider the matter and has granted protection against punitive or coercive action in relation to the incidents concerned. And this is very important as we lie at this stage today after the circular has been withdrawn. The Supreme Court has not made a final ruling regarding the validity of the original BCI circular, whether it was in contravention of the Advocates Act, nor is there a final position on the ambit of Section 24, Section 49, Section 49B in light of the current circumstances. So, there is a solution to this immediate problem that the BCI circular is no longer operating. But that does not solve the underlying legal question. If a regulator can issue a direction like this, withdraw it after public and judicial pushback, and never have the legal basis of that power examined, then the question of what the regulator can do the next time remains open. When there is a challenge to a withdrawn measure, it is not necessarily to bring that measure back to life. It's about asking the court to clarify the limits of such a power which brought that measure in the first place. In a regulated profession like law, it's not always about asking who has the power, but rather what the power authorizes one to do. In this case, this question may outlive the circular itself.